This is Alyssa Hall.
Morning, Your Honor. Deputy Fantoni has Ms. Hall waive formal reading, stand mute, request matter be set for settlement conference and discovery order to enter.
Ms. Hall, can you say your name for me, please?
Alyssa Hall.
Did you go through your advice of rights with your attorney, Ms. Hall?
I did.
Okay. Did you have any questions about your constitutional rights?
No,
And did you allow him to sign your name to your advice of rights?
I did.
Okay. And so in front of me, I have an order for discovery. I will have that signed. We're going to be adjourning this for a settlement conference for your attorney to get the discovery or all the evidence that the other side has. For purposes of arraignment, I'll enter a not guilty plea. Ms. Hall, you're going to have some bond conditions. You're to appear in court as directed. You have a $1,000 personal bond. I think I missed that. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any crimes while released. And you're to immediately notify the court of any change of address or phone number. Give me just 1 second.
I do have a question on that. My bond was returned to
You
me.
don't have to post any money.
Well, I know
personal
that, but I thought all bond conditions were done because the bond was returned.
Well, Ms. Hall, we're doing the arraignment now, which is we hadn't done before. So she's going to give you the bond conditions, but the bond, the monetary bond is personal, means you don't have to post any money.
But you still have to adhere to the bond conditions I just stated. Do you understand? Yes or no? Do you understand, or do you need me to go through them again?
I suppose.
It's a yes or no question, Ms. Hall.
I don't understand how there is still bond conditions when my bond was returned, but that's apparently something else according to my lawyer. So it is what it is.
No, I'd be happy to explain it to you. So you're on bond. So whenever you have a pending case, you are out on bond. Instead of being in custody, you're out on bond. I'm giving you a personal bond, which means you don't have to post anything, but you still.
Before we even get into the chaos you're about to see, let me set the stage for you. Today's courtroom lineup is a masterclass in what not to do in front of a judge. We've got confusion, entitlement, attitude, bad math, worse excuses, and one guy who literally talks himself into jail while the door is still swinging behind him. First up is Alyssa Hall, and right away you can tell something's off. She's not hostile, but she's got that dangerous mix of confidence and misunderstanding that gets people into serious trouble in court. She thinks because money was returned, the case magically disappears. Spoiler alert. Courts don't work like Amazon refunds. Then, just when you think things can't get more awkward, we meet Daniel McGregor, a man who somehow has money for bond, a car in the driveway, unemployment benefits coming in, and still insists the universe is blocking him from hiring a lawyer. Judges hear excuses all day, but this one presses every button possible. Bad logic, victim mentality, and a total lack of awareness about where he is and who he's talking to. And that's what makes this episode dangerous. These aren't criminals trying to escape justice. These are people accidentally self-destructing in real time. Watch how tone, attitude, and timing matter more than you think. Because in court, it's not just what you say, it's how fast you dig your own hole while saying it. Let's get into it.
Off of that original case, because I originally got that bond back and told that nothing further was going to happen. And then all of a sudden I was told I missed a court. So I'm still confused. Is this not the same case?
Okay. So we're going to do a full arraignment. Okay, Mr. Panto?
I'm just confused.
I understand. I'm going to go through it with you because that's part of the arraignment is to understand what you're being charged with. So give me 1 second. Let me
I'm
pull
being
up
charged for disorderly conduct at my brother's house. I understand that.
Okay, that's the
But
charge.
the day my bond was returned and they sent a letter stating nothing is going to happen at this time. And then
They have the right to review and file charges, which they did, and that's why we're at today's point.
all right, can we
so they reissued the charge and I'm reassessing a bond, which means you have bond conditions because technically you're out on bond. I'm assessing you a $1,000 personal bond, which comes with bond conditions. So I see where you would get confused if the one before got returned to you, but we're back at it. They reissued this case.
I just don't even understand how they reissued the case because it was my brother kidnapped my kids, but it is what it is. I have my own issues with Taylor Police Department and everything else right now that I'm going through. So.
Okay, well, you're the one that has the case. So you're the one that has the bond conditions in the jurisdiction of this court, Ms. Hall. Do you understand your bond conditions? Yes or no?
Yep. I know that my lawyer requested discovery, but I
I'm
would
not
like,
talking to you. There's no question. So give me 1 second. I'm looking the report over.
Ryan Lupica is the.
Is there a place?
There's an address.
That's what I'm looking for.
It's Ryan
it's on
Lupica.
Marvin Street in Taylor.
Ma'am, give me a second, okay?
And this is why I hate paper.
I explained to her that the court would require she have no contact with Mr. Lupica or his address.
Yeah, I just need for the
I
bond
don't talk
condition.
to my brother.
Ma'am,
Okay, no,
enough.
don't talk.
Honestly, you're just digging yourself a hole right now, so just stop.
I'm not doing anything.
Ms. Hall, it's easier.
Marvin Street.
Yes.
Okay. Okay, you're also gonna have no contact with Ryan Lupica or 13685 Marvin Street. When I say no contact, Ms. Hull, I mean no contact. That means you cannot email him, call him, or text him. That means nobody can do those things on your behalf. I see you're listening, but I don't need the attitude. You cannot send a text message, a tweet, an instant message, or anything of the like. That includes contact on Facebook, Instagram, Twitter, Cash App, or any form of electronic communication whatsoever. If you have him added on any form of social media, you are to delete him immediately. Sending a blank message is considered to be contact, since I'm instructing you to take specific steps to make sure that does not happen. If the communication comes from you or by the direction of you, it will be considered contact, and it will not be a defense that you accidentally contacted him. If he contacts you, you are not to reply. If he's at a public place, such as a store or a park, and you see him, you are to leave immediately. This is the order of the court. The victim in this case cannot change the order, only a judge can. If he were to invite you over or to ask to meet you anywhere, and you do so, that
Right here is where Alyssa starts stepping on legal landmines without realizing it. Notice what's happening. The judge is calmly explaining bond conditions, and she keeps responding emotionally instead of logically. Courts don't care about what feels fair, they care about what's legally active. A personal bond doesn't mean freedom without rules. It means the court trusts you enough not to take your money, but they still control your behavior while the case exists. And what makes this interesting is her tone. She's not yelling, but she's subtly pushing back. She's questioning authority while pretending to cooperate. Judges see that instantly. When she says, "Not really," after the judge gives a murder example, that's not humor, that's friction. In court, friction becomes risk. Also notice the case background. She bonded out, charges were dropped, then refiled. That happens more than people realize. Prosecutors can reassess, reissue, and reopen cases. So her thinking, "it was over," isn't legally accurate. This moment is important because you can see two paths: cooperate and clarify, or argue and escalate. Alyssa is doing a little of both, and courts don't like hybrids. They want compliance, not commentary.
All right, Mr. McGregor, this is cause number CR 24172, and we're here on a status hearing regarding your hiring an attorney. Tell me where you're at on that.
Yes, sir. I had brought the paperwork that I needed to prove contingency. I brought the pay stub and the worth of my car, and right now I'm in between jobs, so I got approved for unemployment temporarily until I can get another job. I'm just waiting for those deposits to come through because sometimes they take a while to review. So currently I'm waiting for that to.
Do you know how long that's going to take?
Usually they said about 6 weeks sometimes to receive payment, but I'm still looking at jobs, and I've got a few interviews scheduled as well. So
When are your interviews scheduled?
today and this weekend or tomorrow.
So we've had this conversation before, and I've told you that you've applied, and I've looked at your reapplication, and you still make more money than the minimum to have a court-appointed attorney. You understand that? Because you've reported that you have zero expenses, because didn't you say you live with your father or something? Do you live with your father?
Yeah,
He pays all your expenses.
he does.
So all the money that you make can go towards an attorney. The value of your car can be sold. It can go towards an attorney.
It's only worth $1,300.
Well, I understand, but if you've got $3,000 in benefits coming to you, you've got $1,300 in a car, and you've got no living expenses, then all you have is income and no debt. And so state law says that it's going to have to be less, that your income is going to have to be a certain level above your expenses before the court is going to be able to find you indigent. So we had this conversation last time that you may have to sell your car.
This is the danger zone, the part of court nobody takes seriously until cuffs come out. The judge isn't mad yet, but you can hear the patience draining. Alyssa keeps talking while the judge is handling paperwork, and that's courtroom kryptonite. Silence is power in court. Talking out of turn is liability. When the judge says, "You're just digging yourself a hole," that's not sarcasm, that's a legal warning flare. Judges don't threaten for drama. They warn so defendants can save themselves. And Alyssa's response, "I'm not doing anything," is exactly how people talk right before they do something. Then comes the no-contact order. And this part is serious. Judges go nuclear detailed for a reason. Text messages, DMs, Cash App notes, accidental likes, all of it counts. People violate orders because they think loopholes exist. Courts remove loopholes verbally. What you're watching is a behavioral test. The judge is measuring whether Alyssa listens under pressure. Court isn't about being right, it's about being controlled. And right now, Alyssa is walking a line between cooperative citizen and courtroom problem.
It helps you. It would help me get 10,000, because that's $1,300 towards that 10,000.
They haven't released the funds at all, and they're basically still reviewing. And the only money I had was the $111 from Abby's Bagels. So that didn't last very long because I asked them questions about their policy, and they said that it wasn't working out. So
How much are you paying your bondsman?
paying what?
How much are you paying your bondsman?
The bondsman, I paid $5,000 total. But that was when I had a job. HEB supplied my ability to pay. That went away because they took hours away, and I was driving too far. So I've been kind of up and down with jobs. Like I've had 3 jobs the past year, and none of them have worked out very well. Just due to scheduling of new employees and overstaffing, things like that.
All right, Mr. McGregor, I'm going to reset you for 2 weeks. I want you back here on October 17th. You come back and you still have a car and you still have income and you have no expenses, and you come back without a lawyer, we're going to have a hearing on your bond. I may find your bond insufficient that day, and I may put you back in jail. And the longer you sit in jail, the more likely you're going to become indigent to the point where I can appoint you an attorney. You see how it works? If you're going to pay your bondsman $5,000, you're going to have a job, you're going to pay them $5,000, and you're going to get out of jail, but you're not going to hire an attorney to go forward on your case.
I would hire an attorney if I had 10,000 to come up with, but it's just not possible for me.
You've got a car and you're unemployed, right? So you've got a car, so you could drive to all these different places that are all looking for people to hire, right? Sounds like it's possible to me. So I want to see you back here in 2 weeks.
Alyssa exits with a warning instead of a warrant, which already tells you she barely escaped escalation. But now we shift into a totally different flavor of chaos with Daniel McGregor. And this is where courtroom logic meets street logic, and street logic loses every single time. McGregor's issue isn't anger, it's math and mindset. He believes because he doesn't have 10 grand sitting in his pocket, the system should adjust for him. Courts don't work on comfort, they work on capacity. If you have income potential, property, and no expenses, the court assumes responsibility, not sympathy. Watch how the judge dismantles excuses piece by piece. No rent? That's income. Car. That's liquidity. Unemployment coming? That's resources. McGregor keeps explaining his life story, but judges don't grade biographies. They evaluate numbers and behavior. This is also where tone matters again. The judge isn't bullying him, he's reality checking him. And McGregor keeps answering emotionally instead of strategically. In court, explanations feel good, but compliance works better.
Bring him back in here when you get a chance, Fabio. Oh, yeah, yeah. Mr. McGregor, you've just disrupted court with your behavior today and your actions. You understand that?
I accidentally tried to over it the wrong way. I apologize.
I'm going to find your bond insufficient today. Deputy Martinez, go ahead and take him into custody. Mr. McGregor, I'm going to appoint you an attorney.
So I might as well have stayed in jail, basically.
But you're going to jail now, and I'm going to up your bail to $150,000, and I'm going to appoint you an attorney.
150,000.
Yeah, so I said 150,000, $150,000.
For opening the door the wrong way?
No, not for opening the door the wrong way. Do you want me to hold you in direct criminal contempt and sentence you to 6 months in jail, day for day, on top of a child charge that you have? Do you want that? Yes or no? No? Okay.
I apologize.
It's okay. Well, it's done. What's done is done. You'll learn your lesson, I hope. All right. Go ahead and take him, and I'll send over an order.
This is one of those moments that becomes courtroom legend. When the judge says hillbilly math, that's not an insult. That's frustration turning educational. McGregor thinks because selling his car won't magically equal $10,000, it's pointless. But courts think incrementally, not magically. The judge is basically saying, responsibility stacks. A job plus a car plus benefits equals effort. And effort matters legally. The system doesn't reward waiting, it rewards action. What's fascinating here is McGregor isn't refusing, he's rationalizing. And rationalizing in court sounds like resistance. Every time he explains why something won't work, the judge hears why he isn't trying. Also notice something subtle. McGregor paid $5,000 to bondsman but hesitates to pay for defense. Courts see that as backwards priority. Freedom first, protection later? Judges expect defense first, excuses never. At this point, McGregor isn't in danger because of crime, he's in danger because of presentation.
Good afternoon, Your Honor.
Good afternoon, Ms. Conley.
Did you guys need Weathers, or what was the last name?
Yeah,
Weathers.
that's my turn.
Okay.
All right, thank you. You are Casey Lee Weathers, is that correct?
Yes, sir.
All right, Mr. Weathers, I'm Judge Elsenheimer. I'm handling this matter today for Judge Hamlin, who's unavailable. This is an arraignment on a motion affidavit and bench warrant that was requested by the prosecutor's office in Grand Traverse County. And sir, you should understand that, well, before we get to that, let me identify who's here. On your behalf is your attorney, Ms. Conlon. Ms. Copeland is the court reporter. Ms. Henry is the clerk. Mr. Olson is here from the prosecutor's office as well. Sir, the allegation against you is that you had positive test results on the 13th and 15th of October. You had a testing regimen that was part of your bond. The allegation is that you violated your bond, and violation of a bond can be considered to be contempt of court, which can be handled criminally or civilly. If it's handled criminally, it's a separate criminal misdemeanor, carries up to 93 days in jail, a fine of up to $500, but you'd have all the same rights you have in every other criminal case, including the right to an attorney. If you can't afford an attorney, one would be appointed for you at the public's expense. You also have the right to a trial. At that trial, the prosecutor would produce evidence to establish that you violated your bond. The standard of proof is beyond a reasonable doubt. You'd have the right to present your own defense, and if you needed someone to appear, I would order that to happen for that defense. If I thought that the prosecutor or Judge Hamlin thought the prosecutor had met that burden, he'd find you guilty. If he thought they did not, he'd find you not guilty. Ms. Conley, you've had a chance to discuss this matter with your client, correct?
I have, Your Honor. Thank you. Mr. Weathers would admit to the alleged violations at this time.
All right, thank you. So, Mr. Weathers, your attorney indicates that you're going to accept responsibility for the violations on those 2 days.
Explosion. The judge just gave McGregor something rare in court. Time. 2 weeks. A chance. A window to fix the problem. Most defendants would say thank you and disappear politely, but watch the narration carefully. The tone shifts. We're being told something happened off-camera behavior-wise. And that's realistic. People forget court etiquette the moment stress drops. They sigh, mutter, slam doors, roll eyes, and judges notice everything. Courts aren't just legal spaces, they're behavioral arenas. Every movement is communication. When the judge says, "You see how it works?" that's not sarcasm, it's mentorship. He's explaining consequences. McGregor's tragedy is simple. He almost made it out. Almost. Most courtroom arrests don't come from crimes. They come from disrespect, impulse, and timing. And timing in court is everything.
Is that correct?
Yes, sir.
All right, please raise your right hand. You solemnly swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, sir. I don't want you to talk about the domestic violence charge against you right now, third offense, or I suppose it's third or subsequent. We're not going to talk about that at all. We're only talking about this bond matter. Do you understand?
Yes, sir.
All right. The allegation is that you had test results on the 13th and 15th that were positive. It looks like they were positive for alcohol. Is it true that you used alcohol on those 2 days?
Yes, sir.
All right. So no surprise to you that you violated that you had positive tests on those
No,
days?
sir.